Welcome to Doug in Exile.
You have Colorado that says he wasn't an insurrectionist, and then you have the Senate in the impeachment trial where he was acquitted of that.
I'm Doug Tenaple. This is where the Happy Patriots are. As we cover Trump all the way to his hopeful reelection this fall, likely reelection this fall, all the bad guys are falling by the wayside, guys. So let me show you. This is from USA Today. This is another left-leaning newspaper. Anytime that there's news in it, I try and comment on it just to keep you posted, especially when it deals with the Supreme Court, because that makes it super significant. In Trump's Supreme Court immunity appeal, timing of case could be a win for ex-president, which you've heard me say that for over a year now. The timing is even more important than what the cases are about very often, because the timing is about stopping him from being elected. So in the wake of the Supreme Court's decision to hear former President Donald Trump's presidential immunity appeal in late April, legal experts disagree on whether the scheduling is a gift for the Republican frontrunner and whether it signals the justices may be sympathetic to his argument or desired timeline. Scheduling oral arguments for 2 months after the decision is faster than the court's typical timeline for hearing cases, so they are indeed rushing this one along. It leaves open the possibility of a trial in Trump's federal election interference case just before the election. My understanding is that there's a 2-month no-no period that you do not run cases against the president before an election. 2 months is the normal tradition. And the Democrats have no intention of honoring that tradition. They're now throwing out. They're going to politicize this election by having Trump on trial at the Supreme Court within 2 months of the election. So they're running on that. It went from Trump running on he's being persecuted to the Democrats running on Trump is going to be on trial for January 6th insurrection during the election. That's the best thing they have to go on. That will be the conclusion of these 5 points. Now, there is a rule already at the Department of Justice. It's unambiguous. Their cases cannot be election driven. That's what's on trial right now. And that is clear in their rules that Jack Smith, appointed by Merrick Garland, knows that rule. That you cannot have election driven cases. And that's exactly what Trump's insurrectionist case is. It is election driven. They waited to bring it against him until after he announced he was going to run for president. Still, liberal critics who noted the court has moved more quickly in urgent cases, lambasted the schedule for potentially delaying trial or verdict until after the election. They're willing to take up the case, they're going to look at it, and then they'll wait till after the election to give you the judgment. By the way, Sonny Hostin is the one where I learned that the Supreme Court did indeed speed up and go really fast on the Bush v. Gore over the 2000 election when they were counting the hanging Chad. Supreme Court swept in, decided that one quickly. Not much since then has been sped up in this way, though. The reason why the Democrat scumbags decided to throw that rule out that they would not prosecute Trump within 2 months of an election is that they figured the reason why you don't do that is because you're not supposed to influence an election. But they defended, this is in the Mar-a-Lago documents case, the defense attorney said, look, everyone publicly already knows Trump is on trial. So it's not going to affect the election in a negative way for him if we indict him. There's already a public trial. Everyone knows about it, so it's not going to do any good to not do it, to observe this invisible 2-month no-no rule. Many fear Trump will take the unprecedented step of ordering the Justice Department to drop the criminal case if he becomes president next year. They've created a schedule that I think is going to make things very, very difficult. What they mean is it's going to be very, very difficult for them to remove Trump's name from the ballot and influence the election by slandering his name as a felon and all that. Okay. And so I think the idea of the Supreme Court is going to be some form of salvation here is not a sound one. We don't have any reason to believe that, said Cheryl Ifill, the former head of the NAACP Legal Defense Fund on MSNBC. That is a flaming leftist Marxist if I ever heard a job title. So now comes what Jack Smith did before the Supreme Court. Jack Smith proposed, this is on the, I believe it was on the Mar-a-Lago documents case, but he proposed a July 8th start date, which is ridiculously late into the calendar year. But that's what he proposed. Okay. Trump's and his team didn't want to do it. They always want to delay it longer. So Trump's team should have argued for a date after the election, but instead they wanted to try and pin Jack Smith down and prove that he's doing it to manipulate an election. And they said they were willing to have Trump go to court on August 12th. That's just 1 month after that July. Well, August 12th, and with how complicated the Mar-a-Lago documents is with called SEPA, that's when they have to keep documents protected and redacted from the public. And so that it's very hard to argue about them in a court case and have them revealed to a jury and all that, that it's going to take forever. So Trump thinks they're being clever by announcing that August 12th date. So that could be when they end up going to court. Trump's Washington, D.C. federal election interference case, from which the Supreme Court appeal arose, is on hold. So that's good. I believe that's the Chutkin case that is on hold. He faces charges of conspiring to defraud the country and obstruct the presidential election certification process in order to overturn the 2020 defeat, which is absurd. So the whole Democrat agenda is to get Trump indicted on the insurrection, the January 6th insurrection, by election day. That's all they're trying to do now, is to be able to run on that case, which is not what our legal system is for, but that's what the Democrats are going to use it for. It also proves something else, though, that is missing from the whole thing, and that is that they did not successfully impeach and remove Trump. Remember, they tried, they could not get him removed, and that would keep him from being able to run again. So they didn't do that. And they've never proven that he has committed insurrection. And yet that's what they're trying to try him on, is insurrection, without him being charged. Those twofold facts that have collapsed on them in the past are why they're going, well, the only win we're going to get out of this is to get him on trial by election day so we can run and campaign on it. It's marketing, guys. This is not a threat to Trump at all. And Trump's already running on this, that, yeah, they're going after me on election day because they're politicizing our legal system. So both sides want the same thing. District Judge Tanya Chutkin initially scheduled the trial to start March 4th, which is laughable. Let's see, it's March 8th right now. How's that going, guys? But agreed with Trump that many pre-trial proceedings needed to be paused as he appealed over the presidential immunity issue. And we've already weighed in on the immunity issue, that Trump is saying a president will have immunity. I think it's okay that he has immunity. I don't think the Supreme Court is going to rule that he has immunity, because they have not ruled on him having immunity in other cases, like wanting to conceal his financial records when the Democrats were trying to get him to reveal his records. He was trying to say, I have immunity from their subpoena in New York. Trump's legal team has argued that the targeted actions in the indictment fell within the scope of his presidential duties and therefore is absolutely immune from prosecution. That stance was rejected by Chutkin and later unanimously by the Federal Appeals Court 3-judge panel. That's a bunch of Democrats. Now, I do believe in this instant, the president, it's not that he's immune. He doesn't have presidential immunity. It's he has a First Amendment free speech right to weigh in on his opinion that the election, he doesn't have to agree with the results. Special Prosecutor Jack Smith has argued that the legal principles and historical evidence show former presidents are subject to federal criminal prosecution like other citizens. And even if there were permanent criminal immunity for presidential actions, the case would survive because that immunity wouldn't encompass every allegation in the indictment. Here's where they're wrong. He was never indicted for insurrection. What's the crime? So they're trying to make up these crimes and press laws into service that were never meant to be applied to Trump. So they want this felony trial of Trump by election day, and their hope is to get a hostile Washington, D.C. jury pool, a hostile judge, unfriendly Obama-appointed judge on the case, so they can set all their spamming and gaslighting up as if this is some form of justice happening against a political opponent. They want it to begin on Labor Day, which is going to be, say, end of August, early September. And they want it to run through Election Day. Why? This is Biden's campaign strategy. This is the Democrat Party, Biden's campaign strategy. The only thing they've got is to try and pin insurrection on Trump and say, he may not be guilty yet, but just so you know, it's going through our courts in Washington, D.C. Trump is so bad that we actually have him in court over that. That's what this whole thing's about. Okay, here's the other question. Did the Supreme Court speed up or did they slow down? That's anticipating exactly this potential time crunch. Smith asked the Supreme Court to leapfrog an appeals court and take the case on December 12th, 2023. If that's confusing to you, that's okay, because it's all confusing to me too. I'm gonna have to do an illustration with you guys with a calendar and show you all these dates moving around to clarify, because there's no way I can work this out in my head. The justices declined after Trump lost at the appeals court and asked the high court to keep the case on hold on February 12th, pending his expended appeal to the Supreme Court. The justices could have refused his request and ultimately let the appeals court ruling stand. Blah, blah, the blah.
Do you think ultimately the federal trials, which is the classified documents case and the January 6th case from Jack Smith, are going to be delayed until after the election, and then obviously if he wins, he'll dismiss them?
I think the January 6th trial gets pushed out past the election, and the classified documents, I give it 50-50.
I will go back to the simple thing that we can understand is that timing is everything. The Democrats are corrupt. They're not looking for justice. They're looking to slander Trump with any kind of a case, any kind of a charge before the election and make it stick so that they can influence the election results. They do not care about Trump outside of him running for president. None of these cases would be brought if Trump didn't run. That's how you know, because he would have still committed the alleged same crimes, and they could have still gone after him. But if he didn't run for president, they never would have, because they don't care about the law and this breach of alleged crimes. Instead, they just want to affect the election. Now, as the election comes and Trump's going to win, they're going, well, what's the point of bringing these cases if we can't get him before the election? Get it? That's not justice. Justice should not care about the ends before it applies its proper means. And the Democrats have an end, which is to affect the election. So they're going, look, if it doesn't affect the election, why are we pursuing these means and going after this guy? I'm Doug in Exile.